I welcome you all to the higher module on institutional management for entrepreneurship. We are going to focus on intellectual property right, technology transfer and commercialization, and this is the video part 1 of the video series on the topic intellectual property rights and patenting. The contents of the presentation are Introduction to Intellectual Property Rights, Types of Intellectual Property Rights, Relevance of Intellectual Property Rights and how to file a patent. Dear learners, we all are familiar with the word property, which means something that can be bought and sold and which has a commercial value. No commercial value means no property. Most of us are familiar with the physical form of property like a house or a vehicle, etc. But many of us are not aware of the other form of the property called intellectual property. Intellectual property, also known as IP, is the property created by the intellect of human mind having commercial value, or you may say creation of mind or intellect having a commercial value. And what are intellectual property rights? The legal rights associated with the intellectual property are called intellectual property rights, or also known as IPRs. The concept of intellectual property rights is not new. If we peep back into the history, it will be clear that the concept of IPR existed hundreds of years ago. In 1474, there existed an order of law of Venice on the protection of inventions. It has been mentioned that the first English patent, which is a type of IPR, was granted in 1565 for a new type of furnace. Galileo was granted a Venetian patent, that is a type of IPR related to an irrigation machine in 1594. Now, since creations of mind are highly diverse, like a song of a movie, an invention relating to a new screw jack or a new industrial design, if you see, all these have commercial value, but all these are entirely different. Therefore, it is not possible to have a single mechanism to protect all creations of mind. Hence, there are different mechanisms to protect the intellectual property. These different types of intellectual property rights are patent, copyrights, geographical indications, trademarks, industrial design, layout designs of integrated circuits and plant breeders' rights. We will understand these different types briefly. Patent. A patent is an exclusive right granted by the government to the original inventor, developer, researcher of an invention which forbids others from using, making or selling that invention. Copyrights. Copyrights are a set of legal rights that are granted by law to the writers or creators for different forms of artistic, literary and scientific works. Some examples of copyrights are authored books, audios and video cassettes which cannot be reproduced without the permission of the owner who holds the copyright. Geographical indication. Geographical indication is the aspect of intellectual property which is used for products or goods that have a specific origin from a particular geographical region situated in a particular country. For example, in our country, some geographical indications are Basmati rice, Darjeeling tea and Nagpur oranges. That means the tea which is grown in the area of Darjeeling, that is a geographical indication and is known as Darjeeling tea. Next is trademark. Trademark is a sign, word or a symbol used to distinguish and identify the goods or services of one enterprise from those of other enterprises. These are used by almost all the engineering products. So, whenever you are going to start a new product or invent a new product, the first thing one person do is he decides a trademark for his product. Industrial design. Industrial design refers to those elements of a product like specific shape, surface, pattern, color, configuration or combination thereof which produces an aesthetic or ornamental impression of the article. Layout designs of integrated circuits. Layout design of integrated circuit relates to the specific way in which the circuitry elements and transistors of an integrated circuit are laid out in a semiconductor IC, including the lead wires connecting such elements. The next IPR is plant breeders' rights. Plant breeders' rights are the legal rights granted by the government for the protection of plant variety, legal rights of farmers and plant breeders. Now, we are going to discuss what is the relevance of these IPRs. The main criteria for the intellectual property and the associated rights with the IP is to motivate and encourage innovation and creativity among the individuals and the society for the prosperity and progress of the same. The basic concept is that the person who has put in original effort, that is innovation and creativity, must be rewarded. In the absence of such mechanism to reward the original effort and creativity, none would be motivated to do anything new, which would lead to no technological innovation or progress. IPR imparts commercial value to the work and makes sure that rewards of recognition are given to the original creator. Also, it leads to financial benefits in terms of royalty payments which can be transferred to the legal hire depending upon terms and conditions of licensing. The promotion of intellectual property rights leads to economic growth, creation of new jobs and enhancement of quality of life. The progress and well-being of humankind depends upon its ability to create and innovate new works in different areas of technology and cultural well-being. It is important that proper legal systems are present which award the original innovators and thinkers, and also on the other hand punish those who try to copy or benefit illegally from the efforts of others. And lastly, an efficient and effective intellectual property system can help us all to realize the potential of intellectual property as an important tool for economic and social development. There are specific techniques to file an intellectual property right. In this presentation, we are going to understand how to file for a patent. In our country, an idea or invention is patented if it is a product or a process. That means, a patent is awarded only for a product or a process, and the inventions or ideas can only be patented if they fulfill this criteria. The three criteria are novelty. The criteria for getting a patent is that your idea or invention should possess novelty. That means it should be new and it should involve an inventive step, means that it should not be obvious to a person skilled in that particular area. And lastly, it should have some industrial application. It should not only be a theoretical knowledge. There are certain things which are not patentable in our country. These things which are not allowed for a patent in India are something which is frivolous, something which is contrary to the public order and morality or harmful to society or environment. Mere discoveries are not patentable. The substances produced by merely mixing of components resulting in aggregation of the properties of the components, and any process related to produce such substances are not patentable. Rearrangement or duplication of non-devices cannot be patented. A method of agriculture or horticulture or any method of medical treatments are not patentable. Any invention related to atomic energy is not patentable. Plants and animals in whole except the microorganisms. A computer problem, mathematical or business method is not patentable. However, if you have a computer application and you apply it to some product and make a product from that computer application or a problem, then it can be patented. Literary, musical, dramatic or artistic works or any method of playing games is not patentable. Presentation of information, like I am giving this presentation, this cannot be patented. Topography of integrated circuits and an invention which is a traditional knowledge cannot be patented. Now, we will briefly discuss various steps to file a patent. If you think that your invention or the idea is fulfilling the three criteria which we have discussed before, invention should be new, it should have an inventive step and it should have an industrial application, then you can go on and file your patent. The step 1 for this is known as prior art search, means check if your invention is patentable. This means to check if another individual has filed a patent for a similar technology for which you are filing. That means, in simple words, what you are going to patent, it should be new and nobody else should have already done that discovery or that invention. So, it requires an in-depth patentability search. You will have to search the entire patent database, journals, search engines, and you will have to make sure that the invention which you are going to file for a patent should not have been done by anybody else. So, once you are clear that this is a new invention, now you go to step 2. Step 2 is draft the patent application. In this step, you have to prepare the draft of the patent application. The specifications of the entire invention need to be filled in Indian Patent Application Form number 2, which is available on our website. At this stage, one can either apply for provisional or complete patent application. Sometimes we are still doing the invention and we have not completed our invention, then you can go for provisional patent application. A time period of 12 months is provided to complete the invention and file for a complete patent. Now, this is a very crucial point for your patent application, because in this you have to give the entire details of your invention, the steps involved, the drawings involved, the detailed description and an abstract of your invention. After the completion of this step 2, we move to step 3, which is publication of patent. After you have filed the patent, after the completion of 18 months from the date of the filing, the patent application gets published in the patent journal. It will automatically be published in the patent journal. After the publication, till the grant of the patent application, anybody can file for an opposition to the patent application. Next step is request for examination, known as RFE. A patent application is only examined if a request for examination has been made by paying the requisite fees. The request has to be filed within 48 months from the date of filing of the application. After you have filed for RFE, the patent application is examined by the patent office and a first examination report, that is FER, is issued. This report contains a summary of the report and a detailed technical report. The next step is step 5, the examination response. After the examination of the patent application, the applicant needs to respond to the objections which are raised in the FER within 6 months. That means the patent office will send you certain objections which they find in your application, and you will have to respond to these objections, and a time period of 6 months is provided to you for responding to these objections. The next step is step 6, grant of patent. The patent is granted only after the controller is fully satisfied by the applicant's responses. Once you have responded to the objections, and if the controller is satisfied, then he will grant you the patent. The patent office accepts the application, and the patent is granted for a time period of 20 years in our country. Certain documents which are required for applying at the Indian Patent Office, all these documents are there on our website, which has been listed here, ipiindia.government.in. So, these forms are: form number 1, application for the patent grant; form number 2, patent specification form, which can be provisional or complete, in which you will give the entire specifications of your invention; form number 3, which is known as the statement and undertaking under section 8; form number 5 is the declaration of invention, which is to be filled with the complete application; form number 26, it is a form authorizing a patent agent. It is only applicable if you are opting for an agent to file the patent. Sometimes the inventor gives his rights to some authorizing patent agent or to some attorney to file the patent on his behalf. So, then this form number 26 has to be filled. This is similar to a power of attorney, like you give your power of attorney to somebody else and he can work on your behalf. Form number 28 is mandatory only if the applicant is claiming a small entity or a startup status. So, dear learners, once you have successfully obtained a patent, you get certain rights. These rights of a patent owner are: now a patent owner has the right to his invention. He has a right to decide who may or may not use his patented invention. A patent owner can give permission to or can license other parties to use his invention. Patent owner can sell his invention rights to the other party, and after the expiration of the patent, the protection ends and the invention is open and can be used by anyone. In order to keep your patent alive, you have to pay the requisite fees for keeping your patent alive. For more details, kindly refer to the e-content of this unit. Thanks.